Hi, hello everyone. Welcome back to my channel. Today we will begin discussing the glossary of legal terms. The first term is ab initio. Ab initio is a Latin phrase meaning from the beginning. When a contract is declared void ab initio, it is treated as if it never legally existed even from its inception. This means that no third party, however innocent, can acquire rights under it because it is void from the outset. Such a principle was affirmed in Bell v. Lava Bros. 1932 AC 161 HL, where a mystic rendered a contract void ab initio. The doctrine preserves legal integrity by treating null agreements as never having been valid. The next term is abandonment. Abandonment in property or contract law occurs when someone intentionally relinquishes all interest or rights in property or obligations. It often involves leaving behind their physical possessions or rights with no intention of return. For instance, a tenant abandoning a lease by vacating without rent signals surrender of tenancy interest. Once abandoned, property may be claimed or disposed of by others, subject to statutory requirements. Similarly, in a contract law, abandonment of contractual obligations may discharge further performance. Next term, abet, aid and abet. To abet or aid and abet a crime is to assist, encourage, or facilitate the principal offender either before or during the commission of the offense. Liability extends even without the abettor performing the actual criminal act, provided they knowingly support it. A classical example: providing tools or moral support in planning a burglary entails criminal liability. Courts distinguish between mere presence and active engagement or assistance. The doctrine ensures that accomplices are held responsible for contributing to criminal conduct. Next term, abandoned property. Abandoned property is property that has been voluntarily and permanently forsaken by its owner who does not intend to reclaim it. Unlike a lost or mislaid property, abandoned property transfers legal rights to a finder or possessor. Courts consider factors such as absence of intent to return or continued ownership claim. The doctrine serves to clarify ownership and prevent a legal limbo. Statutes or case law often govern the process by which abandoned property is claimed or disposed of. Our next term, accessory to a crime. An accessory to a crime is someone who, after the crime is committed, knowingly assists the offender in escaping justice or concealing evidence, even if they did not participate in the act itself. Unlike abatement, accessory involvement occurs post-offense. In many jurisdictions, the accessory is criminally liable, although often to a lesser degree than the principal. The doctrine differentiates principal offenders from those aiding after the fact. It reflects the moral and legal culpability for facilitating evasion of punishment. Our next term, accession or access acts. Accession refers to acquiring property rights over something added to one's property, such as fixtures or natural attachments. When a property is physically merged or affixed to another, the owner of the principal thing gains rights in the accession. For example, if a tree grows fruit on someone's land, fruits belong to the landowner. Accession ensures legal clarity when distinct items become inseparably united. It is fundamental in property disputes and a land law. Our next term, acceleration clause. An acceleration clause in a contract, especially loans or mortgages, permits the creditor to declare the entire balance immediately due upon certain triggering events. Such events may include a default transfer of title or sale of collateral property. This clause protects creditor interests by enabling full recovery promptly rather than waiting per original schedule. Courts scrutinize such clauses to prevent unfair or unconscionable enforcement. In a commercial leading, they are standard but must comply with notice and fairness requirements. Our next term, additor. Additor is a judicial procedure whereby a court, after finding a jury's damages award inadequate, orders an increase in the amount of damages awarded. It is used to correct undercompensation without ordering a new trial. However, the US Supreme Court has ruled that additor violates the 7th Amendment, thereby forbidding its use in federal courts. Some state courts continue to employ it under restricted circumstances. Its counterpart, that is, remitted, permits reduction of excessive jury awards. Our next term is ademption. Ademption is a doctrine in wills and testamentary law where a specific bequest fails because the testator no longer owns the gifted property at death. There are two types of ademption. Ademption by extinction. Property is sold or destroyed. And a second type, ademption by satisfaction. That is, gift given inter vivos counts toward the testamentary bequest. If the asset is missing at death, the beneficiary may receive nothing under ademption. Courts may look for indent or substitute property to mitigate grace. The doctrine ensures that only existing items may be distributed under the will. Next term, ad hoc. Ad hoc describes a legal body, committee, or proceedings created for a particular purpose, usually temporary and narrowly focused. Examples include ad hoc arbitrators or judges appointed solely for one disputes or tribunal. The Latin origin of the term means for this issue and underscores specificity rather than permanence. It is frequently used in international or complex procedural matters where flexibility is needed. Such structures dissolve once their mandate is fulfilled. The next term, Ad litem. Ad litem means for the lawsuit, and it refers to a person appointed by the court to represent someone, often a minor or incapacitated person within a specific legal action. The guardian ad litem ensures that individuals' interests are advocated during litigation. The role is strictly limited to the proceeding and ends upon its conclusion. It is a protective device to ensure fair representation in complex or specialized cases. Its use prevents vulnerable parties from being disadvantaged procedurally. The next term is actus reus. Actus reus literally means guilty acts, is the physical or objective component of a criminal offense, excluding the mental element that is called mens rea. It may be an overt action, a specific omission where a duty exists, or in some cases, a state of affairs. For example, theft requires appropriation of property belonging to another, and a manslaughter by omission may involve a failure to act when there is a duty to do so, as in the case R.V. Stone and Dobinson, 1977, QB 354. Rarely, merely being in a prohibited situation can constitute actus reus. For example, Windsor versus Chief Constable of Kent case, 1983. It is fundamental for distinguishing lawful from criminal conduct. The next term is alibi. An alibi is a defense asserting that the defendant was not present at the scene when a crime was committed and therefore could not have committed it. It directly juxtaposes the contrary evidence of absence. Defendants intending to rely on an alibi must typically disclose its details in advance to the prosecution. Evidence supporting the alibi may include witnesses, surveillance, or records verified with a credible authentication. When credible and corroborated, it often leads to acquittal. The next term is allegation. An allegation is an assertion made by a party in a legal pleadings that certain facts are true, albeit unproven at that stage. These statements are accepted provisionally by the court unless contradicted or rebutted. Allegations structure the claims and defenses in litigation, defining what is in dispute. They require factual and legal substantiation later in evidence stages. Dismissal or sanctions may follow if allegations are frivolous or unsupported. The next term is amicus curiae. Amicus curiae literally means friend of the court. It refers to an individual or organization that is not a party but offers information, expertise, or insight on points of law or public interest. Court may invite or permit amici to submit briefs that assist in complex issues or broader implications beyond the immediate parties. For example, during the Pinochet extradition proceedings, the House of Lords invited expert legal submissions to clarify diplomatic immunity. The role enriches judicial decision-making with independent perspectives. It emphasizes institutional balance and informed adjudication. Next term, analytical jurisprudence. Analytical jurisprudence is a philosophical discipline within legal theory that uses analytic philosophy to clarify what law is rather than what it ought to be. It focuses on structure, definition, and a logical coherence in legal systems, separating law from morality. Scholars like H. L. A. Hart and Jamie Bentham shaped its modern contours. Core concerns include the nature of legal rules, legal validity, and distinctions between primary and secondary rules. This school underpins legal positivism and the internal critique of legal reasoning. The next term, appeal or appellant or appellate. An appeal is a judicial process by which a party asks a higher court to review and potentially reverse or modify a lower court's decision on a legal grounds. The party initiating the appeal is the appellant, whereas the other party is the appellee or respondent. Appellate pertains to matter of appeals such as appellate jurisdiction or procedure. These courts focus on errors of law or procedure, not re-examining factual findings unless clearly erroneous. Outcomes may include affirming, reversing, remanding, or modifying the lower decision, ensuring layered scrutiny. The next term, arbitration or arbitrator, ADR. Arbitration is a method of private dispute resolution where parties agree to have a neutral arbitrator decide their dispute outside court. It is a form of alternative dispute resolution, ADR, that is typically confidential, efficient, and binding under applicable law. Parties often select arbitration by contract, agreeing in advance to accept its outcomes. Courts generally enforce arbitral awards, giving them legal finality. Arbitration is common in international, commercial, and labor disputes as a flexible alternative to litigation.